Hey, Brian Parker here with another video. We're going to get right to it. This is another review of a company called SoloSuit. I believe they're based in Utah. And they are putting out advertising and videos saying, go to arbitration, file a motion to compel arbitration, and it will make the debt collectors run away from your lawsuit, which in my 30 years of experience of doing this and actively filing on both sides, I've never seen before. But maybe George's a couple of years of experience trumps mine. I'm not sure if even George Simmons, one of the owners of SoloSuit, who's doing these videos, is an attorney, but he advertises for $27 he will make it so that you save thousands of dollars by filing his motion to compel. It's a 5 or 6 paragraph piece of paper that cites nothing and doesn't even follow the rules about filing a motion, which generally requires you add a brief to it when you file it with the court. So by virtue of the fact that the motion that they're selling for $27 to save you thousands, which I'll show you actually costs you thousands potentially, you are going to lose the motion they're selling you. And in the middle of this video, I am going to show you how George Simmons, who does these videos, completely, to me, my opinion, crushes the whole business model of SoloSuit. So watch for that. So what I'm going to do is talk to you and also show you clips of their video promoting that you go through a motion to compel arbitration as a means to saving yourself thousands of dollars. And he actually says this, it will scare the debt collectors away. So let's get into it. The video actually says you will pay $27 and we'll show you how to find the arbitration clause in a much larger credit card agreement from a government consumer website, which is good. The only problem with that is these are quite generic arbitration agreements housed within the larger credit card agreements that are on this giant website. And these things face amendment constantly. So you've got to really go through to find your creditor. And if you're being sued by a debt buyer or a debt collector, there's just so much you have to comb through as part of you're paying $27 and you've got to do all this work, which is really not going to help you in any way. It's like going to a pizza place, paying money and then saying, there's the oven, go make your own pizza. We're not, that's it, you paid us this money. And you'll see why I'm saying that. But again, their premise of their go with us SoloSuit motion compel is pay $27,000 and we'll say $27 and we'll pay you thousands of dollars. Number one reason why that's wrong is every arbitration is based upon the Federal Arbitration Act. So it means you've got to comb through the Federal Arbitration Act if you genuinely want a arbitration of the thing you're being sued for and find out the applicable provisions that apply to your situation. Also with the cardholder agreement of the original creditor, if it's a debt buying lawsuit. Also, you got to figure out where this is going to take place, where your arbitrator is coming from, what rules are going to be applying. None of that is mentioned in the SoloSuit video telling you to arbitrate. And if you don't have those 5 things, what do you do in filing for something you have no idea the concept or basis of? And that's not yelling at you, my wonderful viewers. It's SoloSuit producing this video to, frankly, in my opinion, again, this is all my opinion, my educated experience, this is something you should avoid. It's for $27, what's the expression, for the want of a nail, a kingdom was lost. Anyway, so George Simmons is at it again, avoiding legal reality, and he directs you to go to the CPFB website and he takes you through an agreement to arbitrate. And again, he says, stick with my idea of doing a motion to compel arbitration. because lawyers run from this. They get scared and they will automatically dismiss their lawsuit. That's just watch, and I'll show you places you can watch. First of all, no firm's going to run away from a motion to compel arbitration. Why? Because lawyers love fees. They're going to fight your motion, make a couple of $1,000s fighting your motion and making you look bad because you can't do all this work. You got better things to do. That's why you're going through SoloSuit. And by the way, SoloSuit has a small benefit of avoiding a default. But as I've showed you in my other videos about the importance of a counter affidavit, in my last review of SoloSuit and how they tell you to answer a lawsuit, they fail to tell you the most important part, at least in Michigan and other states. You must object and say in a affidavit form why you don't owe the debt, or why the lawsuit at least is wrong or off base or not being proven. But subtleties and nuances in the law are something that George just skates right over. Again, creditors, lawyers, they're not going to be scared of an arbitration agreement. They're not scared of you. They're barely scared of me, and I'm a jerk. I get a little bit less fight, but I want you to keep in mind that arbitration, mediation, dispute resolution, the person sitting behind the table that you will eventually see if you go through, even lawsuits have the dispute resolution process or case evaluation, where you're either in front of one person or three people depending on the forum, and sometimes those people aren't attorneys. Also, there is a spirit of arbitration, mediation, case evaluation, whatever you want to call it, that says we got to give something to everybody. They will not make a hard and fast rule. There's the King Solomon rule. And the King Solomon rule was back in biblical times. Two mothers claimed to be the mothers of a baby, and they were fighting over it. So they brought the issue to King Solomon, and King Solomon said, well, tell you what we're going to do. We're going to take a knife and we're going to split the baby in half. One mother can take one, and one mother can take the other part of the baby. Stick with me. The mother that wasn't the real mother said, that's fine with me. The mother that was the true mother said, no, I let her have the baby. So King Solomon knew that she was the true mother. Mediators, case evaluators, dispute resolution experts all cut the baby in half. So you could be dead nuts right that you are owed $100 and this guy isn't owed anything. It'll be like $40 to him and $60 to him, because and I've done hundreds of these. I want to be honest, I've done 30 years of them. Rarely do you walk away going, yeah, they were right. It's always split the baby in half. But you won't hear that important nuance in this video. So they advertise, SoloSuit does on its video, and it says, I'll read it, so I'm going to read. Sued for credit card debt? Use our motion to compel arbitration. Our motion to compel arbitration is the best way to beat a credit card lawsuit. Many debt collectors will simply give up. All right, 30 years, try to keep it under 30 minutes. They don't give up because you file a motion. They might do it with an attorney who's well-versed and has supporting law, but the thing that they sell you on, and I'm saying SoloSuit, is, as I said, 5 or 6 paragraph schlocky thing with no support. It's all about how you support your argument. So if you're in this place you don't want to be, where you're being sued, you're not at your best. You're trying your best. You're maybe looking at my videos or somebody else's videos, but you're in the arena of lions, and you're sitting there with maybe a slingshot, and it's their business. And now SoloSuit is sending you into the arena with no arms. Again, this isn't going to save you thousands of dollars. It's going to cost you money. It's a motion to compel arbitration. In my experience, and I've done both sides of the V. I've wanted an arbitration and I've argued against it. The last one was an argument against it and I won. citing the many reasons, one of which was the Federal Arbitration Act, which you should know if you're going to do this. It's unfortunate, but if you look in that agreement George is pointing to, and I'll show you on the video, it says it's done under the auspices of the Federal Arbitration Act, and it lays out all the rules of going through arbitration. So you must follow those rules. And at 1:42, meaning minute 42 of George's video, he says, and I quote, these rules, they're all just legal mumbo jumbo. And let's put that on a video so you can see what I'm saying.
So this clause, says some legal mumbo jumbo, at the election of either of us, us or you.
So that's a person telling you to follow his ideas on arbitration and ignore the actual rules that you must abide by to have a decent chance of winning. He's telling you, and I'll quote him again, that laws and rules are
legal mumbo jumbo. Yeah.
That's right. He calls them legal mumbo jumbo. At 2:09, around 2:09 of the video, he tells you, George does, because he knows better than me or anybody else, just pay me my $27. If you do arbitration, the bank is required to pay for everything. And he points to a section in an arbitration agreement put on his video. Let me show it to you. Shazam.
And what's more is that this one, like a lot of them actually say, it actually says that the bank will pay for the arbitration. And in this case, the debt. Well, that's interesting.
And that's around 2:09. And he's saying, see, you don't have to pay anything. You make those guys pay it. It doesn't say that in his own video. It says quite clearly, if you prevail at arbitration on any claim against us, we will reimburse you for your fees paid to the administrator in connection with the arbitration proceeding. So two things are silly there. Only if you win, well, you're probably unlikely to win if the thing is organized by the credit card company. Number two, we're going to reimburse you. Why is that important? Meaning you have to come out of your pocket all the filing costs and fees before you get to argue this, which you're unschooled on, and I hope you are. And then hopefully you prevail. Well, if they cut it in half, you're going to be owing something, so they don't pay you back. But what does George say at 2:09? The bank is not required to make you pay anything. They have to pay everything. And it does not say that in the agreement. Every case, whether it's arbitration or otherwise, is based upon the four corners of an agreement. You can't ask to enforce a rule that isn't inside of the four corners of an agreement. Whether it's a contract, which if you're signing to agree to go into arbitration, it's a contractual situation. So there's nothing there saying either they're going to pay you back or have to. The only thing the agreement actually says, if you read between the lines, but actually it actually says this, and I'll quote, if you ask for money back, excuse me, we will consider and respond to your request. All right, that's how we're responding. Why would they pay? They're not your friend. So they literally say in the agreement that George points to, we will consider and respond to your request to be reimbursed. So you've got to pay all the money for arbitration, all the fees and charges, unless they're good guys about it and say, now we'll pay. I don't see somebody that's suing you as trying to be a good guy. When you filed a motion to make them go into arbitration, they're suddenly going to go, oh, okay, thanks. You lose your right to win this case that is stronger in court. And think about this. George in his videos talks about debt collectors being forced to go into arbitration and them running away. There's a nuance here, a very important nuance. There are three animals in this thing. The debt collector, the law firm, the debt buyer, and maybe a fourth, actually the creditor, because if it's a debt buyer, they're enforcing a creditor's arbitration agreement they're claiming you signed up for. You'll never find a signature on any arbitration agreement short of lately some bank ones are getting people to sign off. But again, as I said before, even if you look at these motion to compel arbitration agreements, the arbitration agreements on the government website, they've been amended and you've sent notice and you've agreed. It's a mess that they're asking you to enforce and get involved in. But you have to pay for everything and then hope to be reimbursed, hope to prevail, and you just don't want to take that chance. The reality is the following. You don't have to be charged or pay anything if you file an answer and do a counterclaim, a counter affidavit and a counterclaim in court. There's no money. You're not out. Think about it. You already owe a bunch of money. Why come out of your pocket and pay more for something that's not going to give you something that the court is going to give you? If the arbitration is going to award you something, then the court's going to go your way too. Meaning, if you've got a shot at arbitration, it's easier to win at court than it is at arbitration. So if you're likely to win something there, you're going to win in some way at court. It doesn't cost you anything to file an answer and counter affidavit, unless, again, you go through George and SoloSuit Special Services. It's free to file in courts, by the way. Arbitration costs hundreds and may cost you thousands, and there are no rules of evidence and rules of civil procedure which protect you. There are no rules of civil procedure or evidence. So what does that mean? Well, in order for someone to beat you in a lawsuit, that someone has the burden of proof. And you and I have talked and gone over how a counter affidavit eliminates their burden shifting, meaning guy sues you, has a counter affidavit in an account stated case. The burden of proof is on you to do all the proving now. You got to come up with all the paperwork. Your counter affidavit under the statute, both in Michigan and other states, depending on what the state is, puts the burden back on them. They've got to come up with all the paperwork. That subtlety or nuance is very important to win your case. It has no effect in front of a guy from Rhode Island who may or may not be an attorney. Meaning, if a debt buyer is coming after you, they 99 times out of 100 don't have the real proof. They pay pennies on the dollar. They file a bunch of these. They know they're going to lose a couple, but they're going to make a ton of money from the ones that default, or they can force people into making an agreement. So if you've got a Midland Credit, PRA, Crown Asset, UHG, private loan companies, NCSLT, all the debt buyers out there, Calvary's a big one too, and you say, I want to go to arbitration, this is the biggest, silliest thing to do, because you have a great argument in court because they have the burden of proof to show, look, here's the paperwork, their own paperwork, and you've seen my videos. My debt's not connected to this. They paid pennies on the dollar. If you take them to arbitration, by the way, it's not even their agreement. You're enforcing some other creditor's agreement that may or may not apply here. There's no real way to add up the dots. You just legitimatized Midland Credit or PRA or Crown Asset owning the debt. Now it's just a matter of parties coming together to say how much is owed. Whereas in court, you can say, I don't owe anything to this company. You lose that right. You just said to Midland, yep, you owe it, you own it, and you have a right to sue me. I just want to cut it down. It's the worst place to go arbitration with a debt buying lawsuit. But you won't hear that out of George's mouth. He just refers to everybody as a debt collector. That's a horrible thing that he's doing to people. Truth is, again, is you have to pay everything in arbitration, and initially, and if you win, nothing at court. It's cheaper at court than it is at arbitration. Debt collectors aren't running away because you file a motion. They look at answers that are not legally based or with an attorney, unfortunately, or arbitration motions. They just come in full force, they keep it in court, and they drive you nuts. They do not run away. And again, attorneys make legal fees, so they're going to go fight you just for the virtue of the fact they're going to get a bunch of attorney fees, win or lose. All right, I've got to tell you this. At 2:25, this is important. This is it. This is their business motto of their 3-minute, 50 seconds, 59 seconds. At 2:25, George literally says, don't go to court because you will lose and you'll end up paying a judgment. And now you're going to owe all this money because you are going to lose at court. So go to arbitration.
So that means, like, instead of in regular trial court where you're gonna like lose because you don't know the rules and you have to pay for their attorney's fees, which is totally crazy, they actually have to pay for arbitration if they're suing you for the debt. It's a good move, right? So what happens is you can just request for arbitration. That makes the debt collector pay for arbitration if they want to continue pursuing this claim in a trial situation in court, if they want to sue you for the claim. And that's just probably not going to be worth it for them, right?
Think about what SoloSuit is. Their whole business model is come to us, we'll file an answer for you, we'll show you how to do it, we'll even serve the answer to court for you. And yet George says in his video, he owns this company. Don't go to court because the rules are really bad for you. You'll end up having to lose and you'll have to pay the attorney fees of the debt collector. He says that at 2:25, which goes against his whole business model. That's some serious stuff right there. How do you do that? How do you be that unaware of your own business to sell out your business to make $27 on something, frankly, is not going to win? I'll tell you what the SoloSuit website says. Our primary product is the debt lawsuit response or legal written answer. And I'll put it on the screen, Shazam. If you've been sued for a debt and plan to represent yourself in court, this is the perfect way to get started with your case. And yet at 2:25, if you go to trial court, you will lose because you don't know the rules and you have to pay for their attorney fees if you lose. Arbitration avoids that by making the collector pay. As I just said, the collector or the creditor, it depends who's coming after you as to, even if you have a chance of being in arbitration, does not pay anything and probably won't. It's more likely that George will be right on something than you getting reimbursed. So how about telling people what to expect at arbitration, or how it is conducted, or how do you look at the nuances of a debt collector versus a debt buyer versus a creditor? That's some helpful stuff. None of that appears in his video seeking your $27, and you're going down an abyss, my friend. I do not gain anything from telling you don't give him the $27. You're either going to come to me in my state or you're not. I am a consumer protection attorney in my essence. You need protection. Every consumer needs protection from this. And I'm getting more mad the more I see this. And I'm looking into filing a class action, at least in Michigan, because this is hurting people. This advice will and could cost people thousands of dollars. Again, at 2:40, George says, when you request arbitration, that makes the debt collector pay for it. Not true. There's no evidence of that. At 3.03, he says arbitration makes them stop collecting from you, and at the very least, settlement, you're going to get a great deal, below 50%. Now, what I want you to do is listen to the evidence of that. You ready? Here it comes.
That makes the debt collector pay for arbitration if they want to continue pursuing this claim in a trial situation in court, if they want to sue you for the claim. And that's just probably not going to be worth it for them, right? It's probably not going to be worth it. So they're probably just going to stop trying to collect from you.
That's right. There's no evidence that going to arbitration is going to scare anybody and suddenly make American Express go against its very policy of not going below 80 to 75% if you give them a hard time. And he even says, so if you owe $5,000, you end up paying $1,000. Why? Because you paid $27 for something you're going to lose at?
getting your wages garnished at like $5,000 worth of your wages garnished, you can instead offer them a settlement agreement probably below 50%, right? Maybe like $1,000 for a $5,000 debt, right? So that's a great deal, big win for you.
Think about this too. The arbitrator that you're going to be hiring has already been set in stone because they've set the arbitration stuff up for themselves. Otherwise, they wouldn't have it in their own credit card agreement. He or she is coming in from Rhode Island or DC, but he or she is not from your local district area. When you go to district court, you're going to see people you know. You're going to see your plumber. You're going to see your neighbor. For whatever reasons you're there. It's all good. The judge, you may know the judge. So do you want to be in front of somebody that doesn't know the nuances of assignment law? So Midland Credit and PRA and Crown Asset and UHG can say, yeah, we own it. And then try to present him with Michigan law on assignment. He's from Rhode Island and he's likely not an attorney. So do you want to be in front of a judge that navigates this stuff in the community every day, that takes hundreds and thousands of collection cases, sometimes weekly, if possible, but a lot? Or do you want to be in front of a guy that you're just a number, he's got to go out of state, or he's on Zoom? Not that Zoom's bad, but he's not the guy in your neighborhood. Don't listen to George. If you do, that's your right. It's my opinion. Caveat emptor. Also, George is advertising arbitration as a way to avoid garnishments. Arbitration is going to be usually quicker than court. Sometimes, especially with COVID, we're just coming out of it, but there's still a backlog of cases. I see it every day, and there's less people to man these cases. So arbitration, which really has no obstacles, meaning no evidence rules, no procedural rules, you just pay your money and then they hear you. You maybe file a couple of things. You may agree to some rules, but keep in mind the rules are arbitration rules. They're not court rules. They're not evidence rules. So you're going to skate right through to something. Well, if you lose and you're unlikely to win zero at arbitration, they're going to split the baby in half or worse, because you can't prove Midland doesn't own the debt because there's no rules or the right arbitrator or judge to say, okay, I see what you're saying. That's the law. They're not going to apply. They apply what's called the applicable law, meaning their own rules. So you're going to lose, and they're allowed to take that loss, turn it into a judgment, go to court. George doesn't tell you this, and turn it into a judgment so you can actually get garnished quicker. It's very possible you'll get garnished quicker doing a motion compel and putting yourself in arbitration. There is a reason why, it's not a good one, why debt collectors don't like arbitration per se. Because the rules behind getting a judgment and then garnish and then getting 10 years, maybe 20 years of chasing you are favoring the person suing the debt collector. Any chances you have of fighting them also doubly are good for you, but they prefer the nuances of the court system because they're more likely to win more money from you than arbitration. That's true. But George is selling arbitration as a means to pay $1 out of 10 or 5, and you're going to win, and more than likely the debt collector is going to run away scared. Just watch his video. But you have a friend in the court system. I just explained to you. You know the judge. You know this guy. You know the jury. The law is known by the judge. You don't have any of that stuff, and it's costing you money. So you're going to be paying a ton of money to get into a system you're totally foreign unless you sit down and learn the Federal Arbitration Act. So it's going to cost you nothing to file an answer and counter affidavit. And why is it nothing? Where am I going to get that for nothing? You're looking at it. I got tons of stuff on my website. I don't charge anybody. I may one day if this guy's allowed to stick around and make money, but I've done the work for you. Go to Podcast Plus, a collection stopper. Folks, you do what you want to do. It's just $27, right? What if that $27 cost you a ton of money and the guy telling you to go and pay the $27 looks at laws and rules as mere legal mumbo jumbo? You gonna take that guy's advice? And again, his whole business model is selling you responses to complaints, which he just sold out for $27 by telling you don't go to court because you don't know the rules and you don't have money to pay their attorney fees. Well, then why sell an answer to somebody or a legal response to a lawsuit knowing that you're putting them in a place they just said at $225 you're going to lose because you don't know the rules and you have to pay for their attorney fees? Folks, there's no evidence of anything that George Simmons is saying on SoloSuit's video promoting paying $27 for a motion compel. I said this in the last video. I got a nice client that had 4 cases, went through this motion compel. Just on one case alone, it was going to cost her time and money, and she had 4 of them. That's what's going to happen. More time, more money. If you go through, I sue debt collectors all day long. They're not my friends. We have meetings of the minds and it benefits my client, but I'm not going to try to help them. If I thought a motion compel arbitration would screw them over, done. I'd promote it. But even if that was true, the reason, I'm pointing at my show notes, the reason that George gives you are so off base and so wrong, he's dangerous as far as the context of telling you to do something that's going to cost you a lot of money. So, caveat emptor, you can go listen to him and follow what he wants. I'm telling you, in the real world, in 30 years, I've seen it all. This is not a good way to go. The only way this is good is if you hold it as a chip. Let's say you file an answer and a counterclaim, but you know, and it's real obvious that you do owe everything. Well, maybe that request for arbitration, if you can do it cheaply, is the way to go to cut the baby in half of something large that you owe if you go in court. So that's a chip to hold on to, but he's selling it as something you do right away. Also, a proviso, he's never going to tell you the nuance of this. If you litigate a case a long time and then ask for arbitration, a court may rule against you. I just won that motion where I really found some stuff on the other side and I was using securitization. You know my securitization videos. There's one. I have 2 of them, but securitization is the thing, man. And I was just testing this law firm, and I think it was Citibank, and they got real weird. So they suddenly, after litigating for almost 2 years, said, we want to go to arbitration. They said that, right? Court said, no, you've litigated for too long. You waive your rights. I say that to you. I wouldn't do arbitration too soon. If it looks like you're going to die in the case, real bad, you're going to get hurt, then scoot off to arbitration. But don't rush into it the way SoloSuit is telling you. You can do better, much better. Trust yourself. This guy's from Utah. Okay, Utah's wonderful, I love it. But if you're not in Utah, I wouldn't listen to this guy even if you were on Utah. My opinion, caveat emptor, please don't hurt yourself here. Keep watching videos, not just mine, anybody else's that gives you good advice. Free advice, not so much. If it's like this, and I've tried to give you support of why he is wrong, rather than doing what SoloSuit and George are doing, which is just say stuff with no proof. Debt collectors aren't going to run away from you, and they're not going to give you a $1,000 deal and a $5,000 deal.
Getting your wages garnished at like $5,000 worth of your wages garnished, you can instead offer them a settlement agreement probably below 50%, right? Maybe like $1,000 for a $5,000 debt, right? So that's a great deal, big win for you.
Citibank's not going to do that. Wells Fargo, none of them are. Even a debt buyer that paid pennies on the dollar is not going to let you get away with that. Why? Because they're represented by a law firm that wants to keep that account. And unless it's some jerk like me that knows what buttons to push, I don't like this, but they don't respect unrepresented individuals. And they actually come harder in on you to make a point. It's the reality. A concept that there's not much of in this video that I'm critiquing today. Big thumbs down for that video and George's approach. I'm kind of negative. I apologize, but I'm trying to save your butt. I hope this has helped you. Brian Parker again, Law and Lawyering Unplugged. Go to collectionstopper.com, Podcast Plus for everything. This, I think, is the 40th video. So that's 40 podcasts, 40 videos, chock full of free stuff. You're not paying me $27 or anything like that. Get it while it's hot. I hear all day long how useful these things are, and I hope that's true for you. Please comment to me, like, subscribe, and tell me what you want. I will give it to you, and I won't charge you for it. So if there's a video or an issue you want to talk about, feel free to comment, even email me. My email address is somewhere here, but subscribe, man. And remember, caveat emptor. Thanks a lot. Bye.